Good morning, everyone, and welcome to today's session on managing ill and injured workers. My name is James Matson, and I'm a partner in the Workplace Law and Culture team here at Bartia Perry. I'm joined today by my colleagues Andrew Yole and Hannah Lawson. I'd like to begin by acknowledging the traditional custodians of the land on which we meet today, the Gadigal people of the Eora Nation. I would also like to pay my respects to their elders, both past and present, and extend that respect to Aboriginal and Torres Strait Islanders who are present here today. Before we get started, I'd like to go over a few items just so you know how to participate in today's event. For our live stream audience at home, please feel free to send through your questions using the chat function. We'll endeavour to answer your questions at the end of our presentation. For the live audience, please raise your hands and, as I said, feel free to ask questions as we go along. You will also receive a copy of the slides and the recording post the event. Would also appreciate if you could fill out a short survey upon the conclusion of our presentation. So let's now begin. Managing ill and injured workers. It's a topic that perhaps frustrates, that perhaps scares many. It's a topic that navigates many laws focusing on the ill and injured, but the key lies in the word managing. The key to success in dealing with an ill and injured worker is managing all aspects of their absence, including their return to work, their safety and well-being, their doctors maybe, and their employment. You need a fair bit of patience, perseverance, and time. But by active management, you can achieve, maybe within 6 months, maybe within 12 months, either a successful return to work or an exit if a foreseeable and safe return to work is not achievable. But if you forget the absent worker, a year or more then can pass, and when you try to manage their absence or you give us a call, we'll be telling you you're starting behind the 8 ball or at day dot, and we'll need to go through a long dance to put you back on track. So it's hoped that in today's talk, we will help guide you on the different obligations and laws that apply to ill and injured workers, and will guide you through the journey of managing an ill or injured worker. And the other side. Oops, turn it on would help. There we go. Okay. Now this is the typical journey in managing an ill and injured worker. Wouldn't it be nice if that was the only journey you were on? At the time you're managing an ill and injured worker, you may be on another journey at the same time. A journey of managing a disciplinary process, a journey of managing performance concerns, a journey of managing a workplace conflict, and then this journey comes along. We're going to focus on this journey today, but we will at the end try to talk about how you're managing it when other journeys are going along, and please don't be afraid to ask questions, but certainly there can be an interplay. Nothing's ever easy in the life of employment. Now there's of course, the initial stage where there's the injury and the initial absence from work. Now, the length of time of this stage will depend upon the nature of the illness and injury. Perhaps as an employer or someone in the HR department, you'll have less control here. But what you do need to do is you need to stay in touch. You need to stay in touch even if the workers' compensation team is managing the process. And I'll return to why that's important. Then there's the middle. and the middle's the fun bit. The middle's the fun bit where you need a lot of patience. First, there's the treatment and recovery. And again, the length of time, and that can depend upon the illness or the injury or the availability of treatment. But secondly, that tends to interplay with the return to work. Rehabilitation, a graduated return to work, and this stage is probably the most intensive. This is the stage where you're getting more involved and you need to be involved. And indeed, I say to anyone in the HR department, you need to stay involved even if workers' comp is managing the situation. You need to keep in touch. Now, you may find that you're chopping and changing between the second and third stage. You may find that there's ups and downs. Expect a couple of them. Expect a couple of returns to treatment and recovery and a couple of attempts to return to work, but the key here is that you give it a go. Then you get to the end, and the end is really asking, has it worked? And this is where, if it hasn't worked, whether there's been a failure to return at all, or there's been a failure in rehabilitation, is where you ask, do we need to end the journey? Do we need to end the employment? So that's the journey we're going to go on today. Now, like most things in employment, things are never straightforward. Certainly there can be, and people do tend to say, well, there's two types of injuries and illness. There's one that's work-related and there's one that's not work-related. And we're going to talk a bit about that today. But work-related tends to be an injury that arises in employment, that arises out of employment, and it tends to be compensable under the workers' compensation legislation, but not always. You then tend to talk about a non-work-related injury, and that is one that occurs outside of employment, but sometimes that's used when workers' comp deny liability. Now, that's where sometimes you need to be careful because there can be workers' compensation, or workers' compensation can be found to be liable a little bit later on. So sometimes these labels can be a little bit misleading, and you just need to be aware of that. But we're certainly going to examine both today, and we're going to talk about the processes that you adopt. Ain't there enough laws in this area? There's more than enough. We're going to talk some of the key aspects that apply. Certainly those in the state system, you've got the Industrial Relations Act. Those in the federal system, you've got the Fair Work Act. For some in the state system, you might have aspects of the Fair Work Act as well. There's discrimination legislation, both state and federal. There's industrial instruments, there's workplace policies, and then there's workers' compensation legislation. And you've got to make sense of all of them, and you've got to work your way through it. And that's all that arises on part of the journey. So certainly we will cover aspects of that today. So that certainly covers the agenda of where we're going to go today. To begin, Andrew, what are some of the main obligations employers need to be aware of and navigate in managing a work-related injury or illness?
I think to start, I'll start with the paramount consideration of safety. And of course, everyone here would know that that is the paramount consideration for an employer. So if a person suffered a workplace injury, you need to be certain that they're safe to remain in the workplace, if they can remain in some capacity at all, or if they're not safe, then they need to not be in the workplace any longer, and over the time of rehabilitation, obviously. So that needs to colour everything we talk about. And of course, employers take reasonable steps to ensure safety of their workers, and the workers are also obliged to take reasonable care for their own safety. But injuries do happen, and when they do, there is a distinction between a work-related injury and non-work-related injury, as James touched on already. And as James said, a person who suffers a work-related injury may be able to bring a workers' compensation claim under the relevant legislation in your state or territory. And such legislation requires rehabilitation to take place, return to work plans as part of that rehabilitation process, as well as suitable employment or suitable duties as part of the rehabilitation plan or suitable employment. And of course, then the first step to management of the workplace injury is the notification of the injury. So you expect your employees to notify you promptly of any injury. And that's vital in the step, not only from an insurance perspective, but also from getting them the best rehabilitation plan possible. And that's that.
Yeah, and one thing certainly, Andrew, you haven't mentioned yet, and I think we certainly need to talk about, is the obligation to provide suitable duties that arise when a worker is injured. And so certainly one of the goals, as you mentioned, is injury management and return to work. What does suitable duties, as it's known, entail?
So suitable duties is, for the purposes of New South Wales at least, is about, it's a temporary placement in duties for the purpose of getting the employee back to their pre-injury role or rehabilitate them. And it's suitable duties is part of the rehabilitative process in that regard. And you'll see on the slide there, we've got suitable and available employment, which is separate in a way. It's defined separately under the Act as employment in work which the worker is currently suited. And that takes into account all their circumstances, the employer's circumstances, that is, their age, education, skill level, their incapacity, their stage of their rehabilitation process. And it's regardless of whether the employment is available, whether the employment is generally a type of available in the market, and as well as the worker's place of residence, for example. It's quite interesting in the New South Wales space. And the obligation arises under the Workplace Injury Management and Workers' Compensation Act, which does have an exclusion if it's not reasonably practicable. So again, that's then taking, I suppose you've taken the employee's circumstances into account, then you're also taking the employer's circumstances into account. So that's always good to keep in mind as well. And you'll see there the case of Riley's mentioned, and that was a full bench decision of the Industrial Relations Commission. And it found that an employer must take reasonable steps to accommodate the employee's limitations. And this was a dual application of unfair dismissal and reinstatement of injured worker under 241 of the Compact. And Mr. Riley was unable to perform the inherent requirements of his role due to restricted hours. He could only work, limited hours on a number of days per week. The full bench found that it was operational needs of the employer which dictated the inherent requirements of his role. But it found that it was incumbent on the employer to take reasonable steps to accommodate his limitations, otherwise the dismissal would be unfair. And ultimately they found the obligation remained to consider other options to accommodate his limitations despite him being unable to perform the inherent requirements of the role.
And then certainly one of the things that we hear that employers don't like necessarily might be that the worker and their doctor is sort of dictating what suitable duties are to be provided, and they might not be what the business has in mind or what the business wants. And the key there is, I suppose, providing reasonable accommodations, and it's something we're going to talk about, and providing duties that would assist in a meaningful way in that return. But there are limitations in terms of what an employer needs to do. So, Andrew, what are some of the limitations that exist? It's not open slather so far as the worker's concerned, I imagine.
And yeah, so I did mention that not reasonably practicable limitation of the obligation. And so we don't want to be freaking everyone out thinking, there are other considerations. It's not limitless obligations on the employer. So you'll see that decision there of Davidson. That was involving medical retirement process in the police. One of the arguments put forward by the applicant in that case was that the respondent was obliged to employ her as part-time, 5 hours per day, 3 days per week, when on an ongoing basis, when her role was full-time. And the Commission in that case found that there's no obligation to fashion or create a job or position to accommodate the circumstances of the applicant. And critically, that's on an ongoing basis. So that was on a permanent basis, was her argument. And just a side note to that, that was recently appealed, and only a couple of weeks ago, the appeal upheld that decision. The decision of Jenkins was one that our firm assisted the client with. And it was a long-term ill and injured worker who was a wards person, and he suffered a lower back injury in 2016 when he was rolling a bariatric patient at work. He had a period of complete unfitness, then he had periods of different levels of fitness. In that case, the employer took all reasonable steps to try to assist him: rehabilitation, job trials, job placements, vocational assessments, internal and external job hunting. So they really went above and beyond. And it was nearly 4 years between the injury and the end of the employment. So there was a lot of effort in that process. But ultimately, Mr. Jenkins was not placed anywhere else. He did not regain fitness for his permanent role. And he was subject to a fair process, and then he was dismissed. And the Commission said in that case there was no obligation on the employer to provide suitable duties to an injured employee indefinitely. Mr. Jenkins had always just been in suitable duties, having not been permanently placed somewhere else. And then the third case on that slide, Chaniza, this was an employee had been there for a lengthy period of time. Again, she suffered a workplace injury. She was unfit completely for a period, and then gradually returned to certain hours in suitable duties. She was then placed in a position for 12 weeks at a different location, but in that placement she was told that if she was not fit at the end of that time for that role or something else, then the review of her employment would have to commence because of operational needs. And then once she wasn't fit for anything else or her previous role, they withdrew the suitable duties and they issued a show cause letter. The Commission found it was a valid reason, there was a sufficient basis to conclude that her employment should end, but just because there was a valid reason didn't mean it was necessarily fair. In that case, it was found to be fair ultimately, but they were saying there's further questions you need to ask, just beyond the valid reason, of course. And they said the respondent wasn't required to create a role fashioned around her capabilities for an indefinite period of time, and it would have placed an inappropriate and disproportionate burden on the respondent to do so. So there's that balancing of the business or operational needs of the employer in that case, and that will always be a consideration. And even so in that case, so they said you didn't need to create this role, but you did have an obligation to look for other roles for her. And they did look for other roles and there wasn't any available. And that was, of course, looking for roles in accordance with her medical clearance, which was for sedentary work only. And so they looked for roles and none were available. So ultimately the dismissal was not unfair. And we know all of those are in the state space, but there are very similar considerations in the federal space for those of you operating under the Fair Work Act.
And I think it's important to keep in mind that in terms of considering, well, what are the limits on the obligation to provide suitable duties, the workers' comp legislation talks about providing suitable employment, suitable duties if it's reasonably practicable. But you do need to think about it from the perspective of the whole point of this return to work rehabilitation process is to make an advancement. And this is where the indefinite issue becomes quite important, because if all you're doing is giving work for them to maintain their position, then it's not achieving the goal of rehabilitation. It's not achieving the goal of a return to their work, to their role, to their contract. So whilst certainly at the beginning you might put up with suitable duties that are perhaps not as meaningful as the business would like, certainly if there's no progress being made, then certainly what the decisions tell us is you don't need to do that indefinitely. Now, I was out riding the motorbike on the weekend and I fell off and I broke my leg and suffered some psychological damage to my ego. Hannah, if I injured myself outside of the work, what entitlements do I have and what are the obligations of my employer?
Thanks, James. So When an employee is injured or becomes ill outside of work, the first step, of course, is to manage any required absence from work. So in doing so, the employer will have the option to use their accrued leave entitlements, subject to any legislation or applicable state awards. So the first and most obvious option would be to use any accrued personal or sick leave, with the caveat that usually you need to give notice as soon as practicable. The employee will need to give notice as soon as practicable that they wish to use this to the employer, and they need to provide, if required, medical evidence that would satisfy a reasonable person that the sick leave is justified. If the personal and sick leave is used up, they can then move on to taking their accrued annual leave or long service leave if they're eligible for that. But of course, for both of these types of leave entitlements, they need to be in agreement with their employer. So their employer has to agree at the time they're taking it and how long they're going to take it for. Noting that an employer cannot unreasonably refuse annual leave in particular. So finally, when paid leave entitlements are exhausted, the employee can then move on to leave without pay if they still need time off work. Noting that when on leave without pay, this then enlivens considerations for the employer regarding unlawful termination or job protections if it gets to the stage of termination, which we're going to cover later. Of course, not only are there leave provisions under legislation and the industrial instruments, most employers will have policies to deal with non-work-related injuries or illnesses that they need to follow the procedure and process in. In particular, considering how to manage suitable duties, even when workers' compensation isn't made out, or how to avoid any claim for discrimination.
Yeah. And I think that's particularly important for people, certainly in the state system, that there is a policy for managing non-work related injuries and illnesses, and there's certainly, in those cases, there can be considerations to do with industrial relations and indeed long-serving employees to particularly have regard to those policies and follow them. They're particularly important. Discrimination laws will also have a role to play in managing an ill or injured employee, which cannot be ignored. Hannah, what do these entail?
Yeah, so all injuries and illnesses, both out and in employment, can unfortunately be subject to a claim for disability discrimination. So an employee who has the option of making a claim under any state anti-discrimination act, so we have the New South Wales Anti-Discrimination Act there, or of course the Disability Discrimination Act, which is federal legislation and which covers all workplaces, all workers. So the definition of disability, you might not often think disability covers, run-of-the-mill illnesses or injuries, but actually the definition is quite broad. It does cover most illnesses or injuries that you might think of. So that's when we go into what defences are available to employers on the next slide. So if you are subject to a claim for disability discrimination when managing an ill or injured worker, fortunately there are defences available, namely that it's not unlawful to terminate the employment of a person with a disability if they cannot perform the inherent requirements of their job. Before you get to this stage, however, all employers should be aware of their positive obligation to consider how the person with the disability could be provided with reasonable adjustments to help them to do their job. So this sounds similar to suitable duties, and it is a little different because we're talking about a different type of situation, slightly different under different legislation. So I'm going to talk about a few cases now which essentially found what a reasonable adjustment is, namely that it's reasonable if it doesn't impose an unjustifiable hardship on the employer. So in the matter of Tripolis, which concerned an employee working as a lawyer at a law firm, the employee commenced as a lawyer in 2014 and had a depressive disorder, which then turned into bipolar disorder. Over the course of the first year working with his employer, his illness worsened due to a high workload and workplace tension in the law firm. So about a year after he started, he then disclosed his medical condition to his employer and he took urgent leave. He then had to notify his employer that he couldn't actually return to work until he was medically cleared. And what he needed when he returned to work, according to his doctors, was reduced days and a reduced workload. During the period of 2015, he actually did attempt to return to work twice, and his employer actually did provide him with reduced days and a reduced workload, but he still struggled. And so by the beginning of 2016, just about, he was deemed unfit for work. As a result of this, his employer demoted him and reduced his salary, and the employee then brought a claim for disability discrimination, claiming that his employer had failed to make reasonable adjustments and had treated the employee less favourably than other people in the workplace without a disability. Crucially, he wasn't able to make out his claim, as the court found that it was clear that the employer had actually made adjustments during the period in 2015 where he'd attempted to return to work, and he was actually able to return to work when they'd made those adjustments. So this meant that the employer was actually able to rely on the defence that the employee would not have been able to perform the inherent requirements of his work, and it was unreasonable and an unjustifiable hardship to create a new position for him to attend work whenever he wanted to and do whatever workload he wanted to. So we then have the quite well-known case of Watts and Australian Postal Corporation, which concerned Miss Watts, who applied for and wasn't selected for a leadership position in the workplace. Due to this, she then sustained a psychological injury and made a workers' compensation claim. After some time off work to recover, she then successfully began a return to work program. However, during that period when she'd be successfully beginning to return to work, the employer implemented a brand new policy. Under that policy, they then required her to provide medical evidence, advice to assess whether she was actually able to continue in the position that she'd been put into. She objected to this new policy and did not provide medical evidence as requested, so that her employer then determined that she couldn't continue in this position, that she'd been occupying the return to work program. She wasn't fit to perform her duties and there were no reasonable adjustments available for her. She was then placed on leave, and over the course of about 2 years, she exhausted all of her leave and had to go on leave without pay. She actually, during this 2-year period, provided information from her psychologist, her personal psychologist, which showed that she was able to return to work. The employer dismissed this evidence. They didn't believe it was satisfactory. And then further on in the period of 2 years, after which she'd actually exhausted all of her leave, she then attended an independent medical evaluation where she was deemed to be fit and able to return to work, and she finally returned to work. However, she then brought a claim for disability discrimination, claiming, amongst other things, that the employer had not made reasonable adjustments. She actually was successful, and the court found that the employer had not made reasonable adjustments because they themselves had determined whether the adjustments were reasonable or not, which is not actually for an employer or a court to decide. The assessment is actually whether there was unjustifiable hardship for the employer in implementing these reasonable adjustments. So the takeaway from this case really is that all adjustments for an employee with disability are reasonable unless the employer can prove that it poses an unjustifiable hardship to the organisation, which means that all adjustments for an employee with a disability need to be considered and implemented unless there's clear reasoning that it's unjustifiably hard for the organisation.
Yeah, and that certainly has a particular importance when you think about mental health or you know, the interplay with conflict. Certainly, someone might require an adjustment based on the medical advice of their doctor because of a conflict at work, not to work with a particular individual, not to report to a particular individual who they may have been having difficulties with. And quite often businesses will see that as a slight on the manager, that the manager, you know, can't supervise this person. And the question will be, well, can you make that adjustment to help in that person's recovery, to help deal with their disability, their mental disability, which could be quite complex. And certainly to just say, well, no, we're sticking up for the manager, you run the risk of running foul of discrimination legislation. And quite often when you're dealing with these issues, you're going to need to have information at hand to be able to manage all of these responsibilities. I mean, you know, sometimes a doctor just saying, make this adjustment, doesn't provide you with the most useful information, particularly when it comes to safety, particularly when it comes to managed wellbeing. So this becomes a big area of dispute. And Andrew, when it comes to obtaining information to manage an absence, to manage an injury or illness, what are the rights of an employer here?
Yeah, as you were saying, James, it's critical to have evidence-based decisions. So obviously to have evidence-based decisions, we need to have the right information. And that decision there, we're going to speak about a decision of Qantas, where Qantas found itself in a frustrating situation that a lot of employers find themselves in from time to time, where an employee had been submitting medical certificates which were completely vague in their terms. They said he's suffering a medical condition, or just not really providing enough information for the employer. And in that situation, there was an enterprise agreement which had a clause entitled when a medical certificate is required, and it did provide that there were up to 7 days a year you could have which were uncertified, and otherwise a medical certificate was required. So the employee submitted the first medical certificate in July. That certified him unfit until October. Then the day before his period of unfitness was to expire, he submitted another one, which said he's suffering a medical condition which will make him unfit until the 10th of January. That's another 3 months. So then on the 19th of November, the relevant manager wrote to him wishing him a speedy recovery, but saying, we have these operational concerns, we really need more information on this. So please, can you get a more detailed report from your treating doctor talking about your diagnosis, your prognosis, and the timeline basically of your capacity to return to your pre-injury duties. He then also preemptively arranged a meeting to discuss that in December, so plenty of lead time. Then the association got involved, the union for the airlines, and expressed concern about the privacy of its members in requesting that medical information. And it also expressed concerns with respect to this specific member about the progress of the medical process at that time, because there was an active medical certificate on foot. And then the association said that it had advised its members to give limited authority to Qantas to speak to treating doctors for those reasons. The association then also interestingly said there was no lawful basis to request a medical report because the employee was entitled to take sick leave with a medical certificate. And admittedly, that was retracted later by the association. So Qantas rightly didn't accept these assertions, and it issued letters to the employee directing him to provide more detailed medical information, and with the express qualification that if he did not do so, he could be subject to disciplinary action. And then after a number of letters, so I think there were 3 letters, and there was extended time periods, etc., to provide this information. And then by the end, the employee was asked to show cause why disciplinary action should not be taken against him at that time. And then in the meantime, while that was going on, the association lodged a claim for adverse action. Basically, the asserted adverse action was the threats of disciplinary action. And the reason for that threat included the fact that he had provided a medical certificate as evidence of his entitlement to take the leave. And all throughout this time, the employee remained on sick leave with medical certificates, basically just saying he was suffering from a medical condition that he couldn't work. So thankfully, the court dismissed the application for adverse action. The court said, importantly, that there there was strong operational reasons here for the need for certainty for Qantas. In the airline industry, if you return from work after a period of absence, you need to be reskilled or re-examined medically. You need to be cleared. There's extended rosters which are made. There was very strong evidence on the operational needs of Qantas to have this certainty. There were also important comments that, contrary to what was argued by the association, that the enterprise agreement was not exhaustive of the ability of Qantas to request information or what information could be requested. There was discussion of the necessarily implied right of an employer to request medical information to ensure the fitness of its employees, which arose from obligations under the agreement being interpreted by the court, and then also under WHS legislation, which I mentioned earlier. And there was also the general implication at common law under the decision of Blackadder, you may be familiar with, to request information of medical nature to ensure fitness. Importantly, it did also say that the entitlement needs to be exercised reasonably. So in this case, Qantas had acted reasonably. It had first asked for information from the treating doctor. It had asked a number of times. It had also asked a period of time after the unfitness started. So it asked in November when the unfitness started in July. Now, we can't really place a time limit on that, but there was a period of time provided to the employee. It wasn't immediately jumped upon, for example. And then with respect to the adverse action jurisdiction, the court found that the requirement to furnish information did not interfere with Mr. Kiernan's right to provide the medical certificate in support of the entitlement to sick leave. And it also found that a statement by an employer that they're contemplating disciplinary action in the future does not constitute adverse action. So something more than that is needed. And then that led to the comment there. So I'm of the opinion that it would be quite unrealistic to expect Qantas as an employer to be left with substantively no right or ability to require a sick employee to provide it with information. And the proceedings were dismissed in that case. So I think the key takeaways from that are that an employer can request further information, have a critical think about the timing of that and your particular business operational needs for certainty. And there might be, it might just be general certainty as needed rather than in Qantas's case where there was, these specific rostering requirements. But for example, it could also be that you don't want to run a supernumerary position, or you can't for an extended period of time. And then, of course, always check the enterprise agreement or contract or award which you're operating under, which may limit the ability or prescribe certain processes for requesting that information.
And Andrew, if the employee doesn't comply with the request, what are the consequences for them?
Well, if the employee doesn't comply with the request, there can be disciplinary outcomes for those employees, provided it's a lawful and reasonable direction. So that'll need to be considered in the circumstances if it's reasonable. And if it is lawful and reasonable, then there can be disciplinary consequences for them. It can be a valid reason for dismissal. In that decision there on the screen, Salat, it was an unfair dismissal which made comments on the direction to attend an IME. Ultimately, in that case, though, despite the employee being quite argumentative about the New South Wales Police directing her to attend the IME, she did end up attending. She got information. But the commission in that case did say it's well settled that an employee is required to follow lawful and reasonable directions, and these directions are such directions. And then that decision of court and Wollongong University, or the University of Wollongong, it was quite interesting. The student in that case asked for reasonable adjustments to assist her with, I suppose, a vague disability that the university was trying to understand of impaired working memory. And by that, she said she required a person to sit with her for 30 minutes a week to help her with the computer, or she later amended that to say 2 hours per week. And she claimed that she couldn't use a computer, a mobile phone, or other electronic device. So the university asked for further information on that, what she required, asked her to fill out a reasonable adjustments form, which was a usual process of the university. And initially, no further information was provided, but later it was. But that was inadequate in the university's view. Firstly, also on the basis that it was a report dated 2015, and a diagnosis was in 2011, so there was some inadequacy. But ultimately, the tribunal found that there was no differential or less favourable treatment by asking for further information in this case, similar to the Qantas decision.
Yeah, and the complaints that are often made about breaches of privacy and, it's discrimination to ask for the information just often don't pass muster because you're seeking that information for well-being, safety, and so you can do the right thing. You're at the end of the road. Rehabilitation's failed. There's been no, or at least no, successful return to work. You're a year down the track because you've been actively managing it. As an employer, I've got a role to fill. Everyone's doing overtime. My budget's being blown. I've got customers that need to be serviced. How quickly can I move?
Great question. So there are two crucial clocks that employers have to keep in mind. So firstly, under Section 352 and 772 of the Fair Work Act, which means it covers all employers and employees, not just national system employers and employees, it's unlawful to dismiss an employee because of a temporary absence from work. The definition of a temporary absence is 3 months or less unpaid leave in a 12-month period. Any more than that, it's no longer a temporary absence, and you're probably free from the considerations of unlawful termination and general protections. Now, I have to note at this point, because it relates to everything else we've talked about, under the Fair Work regulations, a period of absence while being on paid workers' compensation actually counts as unpaid leave, which leads us into the next clock, which is under the Workers' Compensation Act, it's an offence liable to a penalty to dismiss an injured worker because of their injury for a period of 6 months since the worker first became unfit for employment. That means that 6 months from the date they last performed work, not 6 months from their injury, 6 months since they last performed any work, which means that every time you bring that worker back to suitable duties, the clock starts again. So that's quite important to keep in mind. Now, of course, there's differences based on what state you're in. There we're talking about the New South Wales Workers' Compensation Act, so keep that in mind as well.
So, Hannah, what makes a dismissal of an injured worker fair or unfair?
Yeah, so essentially, whether you're talking about the federal or the state system, there's two things you've got to keep in mind. So firstly, you've got to have a valid and defensible reason. And the second is that you've got to follow a process of procedural fairness. And while there's slightly different considerations in different jurisdictions, essentially this is the same thing. So by a valid reason, in summary, what we mean is that there has been or there is a long-term medical illness or injury which prevents that employee from performing the inherent duties of their position. The decision has to be based on medical evidence, which is available to the employer at the time of the decision. So that's key there, at the time of the decision, because you often see employees coming back 2 months later, 3 months later, saying, look, I'm fine to work now, you dismissed me, this is unfair. Well, you had to go based on the medical evidence before you at the time you made that decision. And then as we've covered, as we've touched on quite a lot, it cannot be for a prohibited reason. So then we're talking about considerations under unlawful termination, general protections, discrimination, what have you. So two quick cases that really show what a valid reason means. So in Roddle and Qantas Airways, the decision concerned a long-haul flight attendant who injured his ankle while he was on his annual leave. He exhausted all his leave accruals and he was then on unpaid for over a year before Qantas then determined to terminate his employment. Interesting, during that process of a year, he was offered multiple opportunities for redeployment, but he refused all of them. He wasn't interested in any of them. So the termination was found to be valid as the employee was unable to fulfill the inherent requirements of his job as a long-haul flight attendant at the time that Qantas made a decision. Crucially, this is one of these cases which I just talked about, in which he then came back a couple months later and said, this is unfair because I can work now. But the medical evidence at the time showed, all the employer could go on was that the medical evidence at the time showed that there was, couldn't reasonably be satisfied that he was ever going to be able to perform his duties in the foreseeable future. So we then have a case in NCAT in the state jurisdiction, which concerned a registered nurse who had hearing difficulties and needed to wear hearing aids and a cochlear implant. So she requested to work only during the evening shift, as medical evidence showed that this was quieter and less busy, and so she was able to cope a lot better and do her work to a reasonable standard. After a period of time, however, her employer then reviewed that arrangement, and she provided medical evidence again, which still supported that she should only work night shifts. The employer decided they weren't satisfied with that medical evidence, however, and they directed her to an independent medical evaluation. And this second report, they then used to decide that actually she should be rostered for all shifts. She should be able to work all shifts. Now, she made a claim for discrimination under the Anti-Discrimination Act, as it was an NCAT. And essentially, the tribunal found that the employer relied on medical opinion which was inconsistent with the reliable and clear medical evidence they already had before it. And as it was clear that the employee was actually able to, she wasn't able to comply with the new requirements they imposed on her, and she was already working under a reasonable alternative. It was clear disability discrimination. The takeaway from that case is that don't go looking for conflicting medical evidence. If you have medical evidence in front of you and it doesn't quite match up, the best thing to do is to give the employee and their doctor an opportunity to actually comment, so that you can actually make a reasonable and common sense decision as an employer as well. So then we talk about procedural fairness. Now, again, in summary, and a lot of this is common sense, a lot of this you would also already be aware of, but you've gone through a process where you've tried suitable alternative employment or redeployment but with the employee, and it's been exhausted. You've made a preliminary decision, which seems valid, to terminate the employment on medical grounds and based on the clear medical evidence you have before you at the time. You've provided the employee with an opportunity to respond and show cause to why their employment shouldn't be terminated, including responding to the medical evidence you're using to make your decision. You then genuinely consider the employee's response, and when you make the decision to terminate, you provide comprehensive reasons for dismissing the employee, and these reasons should accord with the reasons you've given them to respond to already.
Andrew, I've got one more question of you. Dismissing an ill or injured worker must be unlawful, mustn't it?
No, James.
No? Why not?
Well, look, I mean, this case of Western Union and Robinson, some people in the room may have been familiar with it. The first instance decision was quite concerning for employers because Justice Flick found in the first instance that dismissing this employee for incapacity led to a finding that it was disability discrimination because that incapacity was a consequence of his disability. So now this put employers in a very difficult position because in all these cases we've been discussing, if we're talking someone can't perform the inherent requirements, it's inevitably a consequence of a disability because the definition of disability is so broad. So in this case, Mr. Robinson was, by the end of it, on a period of 7 months leave. He was saying that he was suffering from a mental disability. He again had vague medical certificates and he had a workers' comp claim, which certified him as unfit for all employment. There were many times during the absence that the employer asked him to return to work asked him about his return to work date, a timeline, so they could plan. But he just repeatedly provided vague certificates saying he's unwell, can't return, and no indication as to when he would be able to. He was then directed to attend an IME. He initially ignored those requests. He then asked them to speak to his GP or own specialist. And he eventually did agree actually to go to the AME, but for reasons which are not clear on the face of the decision, that was never arranged. And he was then dismissed from employment. He was dismissed on a couple of bases: unreasonable failure to cooperate, getting up-to-date medical information, as well as serious concerns about his capacity to return to work. And then a claim was brought in the adverse action jurisdiction. So as I say, Flick at first instance found no distinction between the disability and its consequences. He said because he was dismissed, part of the reason, he was dismissed was the inability to perform his role. That meant part of the reason was infected by a prohibited reason. And a lot of emphasis was placed on the letter of termination in that regard and understanding what the real reasons for the dismissal were. However, the full court of the federal court disagreed with Flick, thankfully. The full court found that a distinction can be drawn between the capacity to return to work and the underlying disability. It put it as not every consequence of a disability is to be regarded as a manifestation of the disability, such that the consequence is to be regarded as comprising part of the disability. So therefore it can be distinguished.
Which is good news
for
employers.
Yes.
So just trying to wrap this up, and I do want to come back to something that we spoke about at the beginning, which is the other journeys you're on, and one of the key takeaways. Sometimes if you're on a journey, let's say of misconduct, it's serious misconduct, and you're wanting to bring that to a conclusion, but the worker's gone off, you can certainly look to bring that to a conclusion in the ordinary course if it's safe to do so. So a lot depends upon that worker's well-being and liaising with their doctor in terms of whether or not it's safe to, for example, to communicate the outcome. And it certainly does, part of the anxiety and the unwellness isn't helped by them not knowing the outcome, or knowing the outcome but not knowing, because sometimes they've engaged in some very serious misconduct. They know they're going to get fired, and the anxiety of finding that out is part of the problem. When it comes to performance, sometimes it can be different because you're managing a performance process, and perhaps the performance is impacted by the disability or illness that they're suffering, and that you might need to park and go on the journey of managing an ill and injured worker. But it's certainly, it is really fact dependent as to whether you stop another journey or restart it at any point in time. Certainly, for example, if the misconduct involves a number of employees, you might be putting other employees at risk by pausing it and having them not know what the outcome is. So key tips, and in going through it, all I had to do was type on one of the industry publications this morning, injured worker, and up comes a heading, big employers disturbing failure. And I just had to read the first few paragraphs of it, and this is what often happens. So it's certainly a key takeaway. In this case, the employer did all the right things, accommodated the worker's injury enthusiastically and diligently for a whole year, making all sorts of accommodations. The end of the year, workers' comp knocked the claim back, and they went, beauty, you're out the door. A good cricket shot that goes over the boundary for 6, you follow it through all the way. That's why the ball goes over the boundary. And it's the same. You've got to begin and finish as you start. And that means you always got to be proactive in the management of health and safety of your employees and their illnesses and injuries, because you care about their health and safety. Even tip 3, give rehabilitation a go. That's why you're doing it, because you genuinely want to see them return to work if it's achievable. If it's a work-related injury, because you injured them, okay, to put it bluntly. If it's a non-work related, because they're a good employee, because some misfortune fell upon them, because they can't ride a motorcycle. But throughout all of this, you want to obtain relevant information. Be cautious of the divide between workers' comp and employment. Quite often when we have someone approach us and say, oh, we want to move to terminate, we say, okay, what information you got? Oh, workers' comp have been managed to that. You go to workers' comp say, we can't tell you. We can't let you know. So, as part of HR, you want to be involved in the process. You want to be gathering information. You want to be active about what you're doing to rehabilitate, what adjustments you're making, and to ensure the safety. Always be clear on the goals. Okay, so the goals is to get you back to your job, your full-time job, with the full demands and rigours. If that's not achievable, for whatever reason, you change the goals and be clear on what you're working towards. If you're not clear on what you're working towards, you end up in this land where no one really knows what's happening. Keep an eye on the clock. The 3 months to 6 months, it's a big clock, and it's very disheartening. You can hear the penny drop when you say to someone, oh, thank you for calling. Yep, okay, you're 18 months down the track. We're now going to wait 6 months. Okay, so if rehab's not working, if that goal's not working, you're going to need to think about putting the person off work so that way the clock can run. Okay? And ultimately, you act because there's clear evidence. So as you've got clear medical evidence that there's no foreseeable return to work, and knowing that you followed a fair process. So you've looked for other opportunities of redeployment. You've looked for other opportunities before you actually end the employment. They might not be able to return to their role, but at least, hand on heart, you've followed a good process. You haven't dropped the ball at the end like this big employer did the second the workers' comp. If they followed through what the Commission was saying here, within 3 months you could have ended it fairly, lawfully, without a problem, because you had gone through the process and then it hadn't worked, hadn't achieved the outcome, because ultimately, even though they dropped the ball straight away, what they were able to show, there was no other roles for this worker to go to based on their capacity. So sometimes it is that patience, sometimes it is that perseverance. So we've got some time for questions. We've got 2 online as well.
There are 2 questions. Is return to work plan required for non-work related injury?
No, but it's not a bad thing to have. Some policies may require it. Again, the beauty of a return to work plan is that it actually sets the parameters of what you're working towards. It sets the guidelines, and it also creates a framework in which you can get that information. So hopefully you don't have that fight over grabbing medical information.
Working within a team that has either a confidential personal conflict or a mental health issue at its core is very confusing and complex for the entire team. Any advice? Should the team be advised of any details as the team dynamics have obviously changed?
Okay, so as I understand the question, and I hope I get this right, is there's a mental health issue, there's difficulties within the team, how much should you disclose to everyone else? Safety and wellbeing will guide that. As Andrew said at the start, your work health safety obligations are quite important. If you were to just disclose, hey, you're having difficulties because Joe's mad, you're probably going to cause yourself a whole world of pain. You've got to be having a discussion with Joe about what you disclose, about how things work, and then working out what's the right thing to communicate to a team. What's the right thing to share in terms of providing a safe workplace for everyone in a place that is functional. It's a bit like you may be working with someone that has epilepsy and can have a fit at any time. A business might tell people around that this could happen and what to do, but you don't advertise it to the whole workplace. And the reason why you do that is because you're managing safety and well-being. So that would be a discussion that needs to occur, but certainly at the end of the day, it's the employer's obligation to ensure safety, and the employer would need to make that call.
questions that have come in?
Anyone in the room first? There's one? Yeah. Sorry.
Just a quick question. We had a worker go off work, ostensibly because of a non-work related condition. The worker then disclosed to us that in doing the various x-rays and scans and all the rest of it, they discovered severe degenerative conditions in his neck. Now, the worker says, okay, the temporary aggravation has now ceased. It wasn't work-related. I'm ready to come back. We've got the information from him. We haven't even seen the report. We've got information from him that he's got this severe degenerative changes. Are we entitled to ask for more information? Are we entitled to say to the doctor? So do you understand what I'm saying? Do we have let me put it differently. Don't we have an obligation to make sure that we're not putting him at high risk by simply returning him to work?
Yes, you do have that obligation. That would be completely reasonable to ask for further information, initially from the treating doctor, and if that's not well, then you'll have to direct him to provide it to you. Yeah.
I mean, can you imagine the exposure to another workers' comp claim or a prosecution where you knew something and you took no steps to ensure safety? It'll be diabolical for the employer.
Yeah.
And that's the Qantas case, in effect.
Yeah, it would need to be a firm direction that he's on notice of his requirement to comply with.
Last question.
Should the non-work return to work plan be different to the workers' compensation one?
It doesn't have to be, but invariably it would be. I will say this, workers' comp are really good at managing ill and injured workers. You have a case coordinator, case conferences. There's a lot there that can be deployed in a non-work related injury. You don't have to, but it's certainly useful. Certainly useful to use those skills and tips and tricks. All right, thank you everyone. Great to see you, and I hope you all enjoy the rest of your day.